This is a sound check. We'll be starting our presentation in just a few moments. Well, hello everyone, and welcome to the Arcadia Association of Realtors webinar for today, September 15, 2020. I'm Kelly Richardson. I'm an attorney in the area, and I'm happy to be with you today. I'm hoping you can hear me all right. Please note a couple of things as we get started. There is a question box at the end of the presentation. I'm going to be consuming about 45 to 50 minutes of prepared remarks. And then I'm trying to reserve about 10 minutes at the end for questions. So if you have questions, if you could use the question tab on your toolbar, you'll see that you can click on that and type in questions, and I'll get to as many of those as I can before we're finished with our time today in about 58 more minutes. Also, if I could, I'd like to ask a few questions about all of you today, so I know who I'm speaking with. If I could just ask a couple of quick questions. First of all, which association of realtors are you a member of today? Are you part of Arcadia, PFAR, Pacific Foothills Association, West San Gabriel, or another association of realtors? Give just a few more moments for people to key in their choices. We welcome all of you, no matter which association you're from. And of course, I know that Arcadia and Pasadena Foothills always welcome anyone, any real estate professional who wants to attend. But it looks like we have mostly Arcadia members today, some West San Gabriel members as well. So thank you for that. And one other question pertinent to our topic today: have you ever had a client in a dispute about property size after close of escrow? Have you ever had to deal with this before? So let me just find out what our experience has been here today. Take just another moment to give you a chance to key in your responses. Fortunately, most of you have not had this happen with one of your clients, but I see a few of our attendees have been through this unpleasant experience. So appreciate knowing that. Well, let's move on. Again, please use the question box during the presentation today. You can type in your questions whenever you like. I will be not looking at them until we get to that 50-minute mark. And again, I'll answer as many as I can. If you have any technical details in logging in today, please email jana@rodllp.com or call my office. Hopefully, if you're hearing or seeing this, you're getting all of the presentation. All right. One thing I do need to emphasize anytime we talk about risk management topics, that this is simply a presentation of suggested best practices for minimizing exposure to liability. Nothing I say today should be construed as a promise that if you listen to everything I say and implement everything I say, that you won't have any lawsuits or claims or problems. I'm going to do my best to try to reduce the chances, but I certainly can't promise that you'll never have a problem or that your clients will never have a problem in this area. If a claim does arise, relating to any liability, breach of contract, breach of fiduciary duty, professional negligence, seek guidance from an experienced and qualified attorney immediately. If you're an agent, go to your broker, let them know immediately that there's a claim or a dispute that could become a claim, and they will direct you to the attorney with whom they are the most comfortable. Square footage is a recipe, unfortunately, oftentimes for lawsuits. And let me explain what I mean by that. Nothing gets a buyer more upset than the impression that what they thought they were buying was actually not what they were buying. In other words, that they thought they were buying a 2,300 square foot home and it turned out to only be 2,200. That is a big problem. It is something that people get upset about, and very quickly people often go to the assumption that, well, then if this house was worth so much per square foot and I'm 100 square feet short, then I should be compensated for that shortfall in the square footage. And you experienced realtors listening know that that isn't necessarily an accurate way to look at it. But I think that's the way that a lot of folks look at it. They look at it, unfortunately, when they find that the size of the property is not what they thought they were getting or what was represented to be sold or leased, they automatically go to the assumption, I'm sorry to say, that this was not accidental, but that it was intentional. I think it's a cultural thing, perhaps, but it just seems that nobody believes that accidents happen anymore. And it's unfortunate that people automatically go to the assumption that something deliberate happened here. There wasn't just a misunderstanding, or maybe the seller was told the wrong square footage, or maybe nobody ever really knew for sure what it was. And unfortunately, the assumption of many upset buyers is that this must have been deliberate. They were trying to take advantage of me, and they go right away towards intentionality and using awful words like fraud and misrepresentation. Well, the commercial and residential real estate markets deal with this very differently. Many of you who have experience in commercial real estate or particularly commercial lease agreements, you'll note that a very common provision in a commercial contract is that the tenant or the buyer stipulates to the stated size of the property, regardless of what it actually is. In other words, okay, tenant, you think that you're leasing a 10,000 square foot building. If it turns out to be 9,500 square feet, well, too bad. You're specifically agreeing that this is the size of the property. So you better do your due diligence. You better measure yourself beforehand, because you're waiving any argument later that the size is something other than was in the contract. Another thing that's interesting about commercial leases is that there's a measuring standard that's often very different from what most of us would think. And the BOMA, the organization that establishes the commercial measurement standards, they have a very complicated formula, and it changed a number of years ago to basically, if I understand it right, they'll measure from the middle of the exterior wall in. And of course, as many of you know who've dealt with commercial leases, that square footage not only includes half of the thickness of the exterior wall, but lots of areas that are considered rentable but aren't really usable. Well, anyway, in the residential world, it's very, very different. In the residential world, how do we deal with square footage and size of property? Well, we use the word approximately, or we say plus or minus a lot. And then we say it again, and we say it again. And so frankly, the residential real estate transactions are frankly much more likely to have a square footage problem, because we don't really deal with it, I think, as directly and decisively as the commercial real estate market. So let's go look at what are the types of claims that we come up against when somebody believes that there has been a misstatement or a inaccurate representation as to property. Well, of course, first and foremost is the allegation of misrepresentation. Misrepresentation or fraud, deception, there are many words for it, but this is an intentional tort. This is an intentional act by which, in the traditional definition of misrepresentation, the utterer of the statement either says something or fails to reveal something which is material and which harms the buyer, the listener of that remark. So by material, the classic definition of what is a material misrepresentation. In other words, it's not just a false statement, an intentionally false statement, or an intentionally concealed statement, but it's something that is material. Well, material in the law means that it would affect the buyer's decision to buy at that specific price. So if somebody says to you, well, that toilet in the guest bathroom is a $5,000 toilet, and it turns out it's really a $4,000 toilet. Well, that may be a misrepresentation. It may be a false statement, but it probably wouldn't affect most buyers' decision to buy at the price that they agreed to pay. A failure to disclose must also be material. If a seller forgets to tell you that 2 years ago they had to replace their water heater because it failed, well, okay, maybe that's something that they should have disclosed, maybe not, but it's not material. That wouldn't change the price that a buyer would be expected to pay for the property. So that claim is the first one that comes up, and it's typically asserted against both the agent and the client. And you might ask yourself, well, wait a minute, why do they assume that I didn't live there? I'm just the realtor. I'm the listing agent, the listing broker. How do I know what happened in the property 2 years ago? Well, unfortunately, very commonly, property buyers assume that you realtors know everything, that you have all knowledge, and that you know all things. And that's really unfortunate, because it's not reasonable. It's certainly not fair to you, the real estate professional. But that is a very common attitude. I'll never forget the call I got a number of years ago where, and my office doesn't sue realtors or brokers, but I got a call from a home buyer, probably 12, 13 years ago at least now, it might have been 15, and they said, I'm upset and I want to sue the person who sold me my house, and I want to sue the realtor for fraud. So I asked them a few questions. Well, what's going on? And the typical response is usually, well, I found something's wrong with the house that I bought after I bought it. And I talked to the neighbor, and the neighbor told me, yeah, there were roofing repairs going on. There were roof leaks in that house before. So then I asked the person in this particular conversation, I said, well, wait a minute. So tell me, why do you want to sue the realtor for fraud? Why do you say that they knew about the they knew that there were these roof leaks? And the statement was, well, they're supposed to know. They're professionals. That's their job. Now, that's not fair or reasonable, is it? You're not know-all, see-alls. You're human beings, and you get hired to list a property, and very often you don't know every single thing that went on. But I just want to alert you that there are unrealistic expectations of you by the real estate owning public. So they go right away to this misrepresentation, and typically they're inclined to pursue both the realtor and the realtor's client. Well, the next theory that often comes up in the cases on this is something that's called negligent misrepresentation. Now, negligent misrepresentation is also typically asserted against both agent and client. And negligent misrepresentation is not a lie or deliberate concealment, but it's saying something as a fact that is a material fact that in fact the person who said it really has no idea if what they said is true or false. So if I told you that I was selling you a restaurant property in Temple City, and I had heard from a friend that there's going to be a huge hotel going in the next 2 years next door to this restaurant property. Now, of course, I'm trying to get the property sold. I'm excited about that. I think this is going to get the buyer excited as well. So I may be very tempted to relay that gossip to the buyer. That might very well cause the buyer to go ahead and buy that restaurant property, knowing that there's this huge hotel project coming in to bring lots of hungry potential customers in the very near future. But see, the problem is that when I say that to the buyer, to the prospective buyer, that there's this huge hotel going in, I have no idea if that's true or not. I haven't done any due diligence. I haven't checked it out. It was just chit chat at a party. Well, that very well could be negligent misrepresentation, because if that person buys the restaurant property and they find out that in fact there's absolutely no plans, as it turns out, to convert the property next door into a big hotel, then that would dramatically affect the desirability of that restaurant property and give rise to a claim for negligent misrepresentation. So again, negligent misrepresentation is not that you lied, but that you said something without having any basis of knowing if it's true or not. And I think cocktail chatter certainly would fall into that category. So that's negligent misrepresentation. Another claim that is often brought when people are pursuing real estate professionals is the allegation of breach of fiduciary duty. That the listing agent in a dual agency situation, that the buyer was not adequately protected, that the agent for both sides did not disclose everything they were supposed to disclose. And so we have that potential claim. That is not typically asserted against the property seller, but it's asserted against you, the realtor. Also, negligence is a claim. Now, the negligence claim would be the failure to fulfill your duties as a real estate professional consistent with the standard of care. Now, that claim would be from the client against the client's realtor. You wouldn't be suing the other party's realtor. You would be suing your own, saying, I got bad advice. You gave me bad information. You told me to fill out the forms incorrectly. Things like that. That could be a theory of negligence. And lastly, the claim of breach of contract. When we're talking about square footage, the client who thought they were buying the 2,300 square foot detached home and then finds out that they only actually got 2,150, they might simply say, I contracted for a 2,300 square foot home. I didn't get that. This was a material breach, and therefore I'm suing the client, the seller, for breach of contract. So those are 5 of the claims that I think most commonly could arise in the situation of a square footage error, a square footage misstatement that is later discovered by the buyer. And of course, the first thing that you probably thought even before you signed up for this, and this is why I put it in the title of the class, why doesn't the word approximate end the discussion? I mean, we're all trained from day one as baby realtors to make sure that we never pretend that the square footage that is quoted is accurate. We use words like approximately. We use symbols like plus, slash, minus. And we think that, well, that ends it right there, right? Because we said approximate. Well, the problem is that if the shortfall in square footage gets to a sufficient magnitude, it can be considered outside the scope of approximate. And in my litigation career, in handling these cases over the many years, many times I've seen expert appraisers testify in court not just appraisers for the plaintiff, but appraisers for the defense would all typically agree that by the time you get to a discrepancy of 10%, my experience is that both experts will agree that that is a material breach, that it's outside of the word approximate, it's not covered by the symbol plus or minus, and then they simply go to, well, so what is the economic impact of that shortfall? So just know that approximate is not unlimited. And could a shortfall of 8 or 9% in the property size be considered a material breach? I don't know. I wouldn't want to be in that situation, but that, if it's a larger home, could be a significant amount of square footage. But know that certainly by the time you get to 10%, my experience is that 10% is generally agreed to be outside the term approximate or plus minus. So a misstatement about something that's outside the word approximate then would be material. Why is it material? Because it goes to the very basic characteristic of the property, the dimensions, the size. How much is the buyer buying? So that misstatement, most likely, if it's outside approximate, it's also going to be considered a material. Now, we don't want to get into a question of, well, gee, Kelly, it wasn't 10%, it was only 8.5%. That doesn't mean you're safe. I'm just telling you that by 10%, my experience is most experts in lawsuits that I've taken to court have agreed that 10% is a problem. What about 5%? What about 7%? Well, I don't think you want to be in that position. Maybe the plaintiff expert says, oh yeah, that's 7% is material, and the defense says, no, I don't think it's material. And then it's going to go to the hands of a judge or jury or arbitrator, and they're going to be the ones ultimately deciding. You really don't want to be at risk of that, I don't think. So you don't want to find out how low could that shortfall go before it's no longer considered material and we're back in the safe protection of the word approximate. Another thing is we're going to talk about the forms. We're going to talk about the forms that California Association of Realtors has for you. But I think that there's a dangerous myth, frankly, out there that the CAR forms absolutely protect you, that you really don't have to worry about it because we do have these words like plus or minus or approximate. Don't believe that the form absolutely protects you. It does not absolutely protect you. A major discrepancy is going to be found to be outside the protections of words like approximate that we see in the CAR forms. So, moving on to the next topic, after we get past the word approximate, of course, the next thing that all of us think about is, well, Kelly, all I do is count, I quote the assessor information. I say per assessor, 2,300 square feet per assessor. Or I just quote a square footage and then I mention that it comes from the assessor. Is the county assessor a safe harbor for us? Well, no. The county assessor is absolutely not a safe harbor, not at all. Why can you not rely on the assessor? Well, there are many reasons, and I want to walk through those with you because I find that it's really almost an urban legend in real estate that, well, all I did was I passed along the county assessor. I just put the assessor square footage in my MLS listing. Well, that may be something you do, but you need to have some understandings about, you need to understand some things about the assessor information so that you can adequately educate your client. And here are some of the facts that I want you to know. First of all, does the county assessor define property? Because if we're talking about the size of a lot or the size of a home, then I guess if the assessor defines property, we can rely on that, right? But the assessor doesn't define property. Does the assessor calculate property size for you, for the real estate professional, or for the home buyer? No, No, the assessor doesn't. The assessor takes those square footage calculations so that they can determine what they will assess in the way of taxation against that property. That's the only reason they're doing it. They're letting you know what is the basis of the property tax calculation for that property. It has nothing to do with you or with me or our clients in terms of quantifying the property. This is just how they calculate the tax. What about if the assessor's square footage is wrong? The lot is actually smaller than the assessor calculates. Can we hold the county liable? Well, you probably already know the answer to that, right? No, we cannot hold the county liable for variations in the square footage. So then, if the assessor isn't defining property, if the assessor's calculations are actually not meant for you and me at all, and if the assessor can't be held liable for mistakes in their calculations of square footage of building space or lot size, well then, can we safely rely on the assessor as a defense? If somebody says, well, it was 2150 and the assessor and you said it was 2300, can we rely on that as a defense? No, you're probably ahead of me. You cannot. So if you misquote, if you include in your listing 2300 square feet per assessor, okay, that's okay, because all you're saying is this is what the assessor says. But my point in this, and I am going to hammer this a little bit because it's such a rampant problem in residential real estate, is that people think that that's the end of the discussion. And your buyers, your clients don't understand that the assessor is very often not right, that it's very often inaccurate. And we're going to talk about that in a few moments. But you need to alert your clients that the assessor information is interesting. It's useful, but it is not legally considered accurate, and it's not considered something that you can rely upon as a seller. If somebody says, hey, you told me it was 2300 square feet and that was very seriously inaccurate, you can't defend yourself by saying, well, all I did was I quoted the assessor. Okay, so the moral of the story is, if you're relying on the assessor data for an MLS listing or a flyer, you probably already know this, always mention that it's per assessor, that it isn't independently been measured by the client. But I think you need to go a step further, particularly as the buyer's representative, and make sure that your client buyers understand that that doesn't mean that the property really is 2300 square feet, because it may not be. That's just what the assessor thinks it is. The department in the county that actually records the definition and therefore the dimensions of property is the registrar recorder, the county recorder. That's their job. So if you're looking for legal descriptions, if you're looking for tract maps and you want to see the exact dimensions and boundaries of a property, you don't go to the assessor, you go to the county recorder. The problem is that the county recorder doesn't have any need to calculate the square footage shown in a map. They don't need to measure the indoor space of a condominium. All they're interested in is documenting the location of the property and its boundaries. What you do with those boundaries is up to you. So of course, we don't use the county registrar recorder. We use the assessor because the assessor's information is so convenient. I mean, even our clients these days can pull it up off the internet. But the registrar recorder has the accurate definition of property. Very often in condominiums, we will have to pull the condominium plan to be able to determine whether or not the garage is considered part of the condominium unit, or to determine whether or not the yard space in front of the condominium or in a planned development property, whether the lot is simply the footprint of the building, whether the lot being sold includes the front and backyard of that goes with the property. So that all comes from the registrar recorder. In speaking about condominiums, one thing that you need to know is that the condominiums are almost certainly, I mean, I can almost guarantee that condominiums are measured incorrectly by your county assessor. Now, how does that happen? Well, it happens in a couple of ways. First of all, with what we call an airspace condo, the classic and not the universal definition of a condominium is airspace surrounded by the unfinished floor, ceiling, walls, surfaces, right? That's the classic definition. Now, that is not universal. There are condominiums where the description of the condominium is everything above the slab. I was working with a client 2 days ago who is buying a condominium in Los Angeles County where it's what I call a lot line condominium. The condominium map shows the boundaries of what otherwise looks like a lot. There's a side property line and another side property line and a front and back property line. And the entirety of everything within those four perimeter lines is considered the condo unit. Well, the airspace condo is far more common, but the assessor personnel, when they measure condos, and this comes right from the Board of Equalization, the way they train these folks is they measure corner to corner. So what they're doing is they're treating it as if it was a freestanding building, and they're measuring the entirety of the structure. So that means they're not deducting for voids, for the bearing walls. They may be including balconies or porches sometimes. And the outcome of that is that the size of the unit is typically overstated by the assessor. Now, where does the typical developer get their square footage information? Well, they get it from the same place the assessor does. They go to the architectural plans, they look at those blueprints, and they calculate from the blueprints. They run calculations on how big is the condo unit, but they're not deducting for the walls. They're not deducting for any interferences, any structural columns, and so they're including everything. And by not just going paint to paint, in my career, I've seen discrepancies anywhere from 5 to as much as 12 or 13% deviation from the assessor and therefore the developer's representation to the actual measured floor space of the average airspace condo. So that's why oftentimes you're going to see developers who are without question using the assessor information. Well, they're all getting it from the same place. They're doing a very rough takeoff from the blueprints, and that means that that condominium is going to be overstated. Now, that creates another problem. Is not only do you have condo buyers very often very upset, but when you have CC&Rs that allocate assessment responsibility based on the alleged square footage, you've got people apparently paying more than they're supposed to pay because their condominium unit is actually smaller than what the CC&Rs say it is. And that can lead to turmoil in the HOA. Very common problem in HOAs, very, very common. Now, the only solace is that your condo is probably overstated. Excuse me. Well, so is everybody else. So chances are, excuse me, chances are everybody's condos have been overstated. It's just a question of how much. So I think the practice pointer I would suggest that when you're dealing with condominiums, you have to be very, very cautious to alert your buyers. They need to understand that what is going to be the most important is they look at their appraisal report before they close escrow. They're almost always going to find that the appraisal report gives them a different square footage number than they got from the assessor and that they got from the seller or even the developer if it's a new property. Alert them to that so that they aren't angry at the very end when they see the discrepancy, but also so that they're prepared. If the discrepancy is too significant, that they're uncomfortable with it, that they can go ahead and cancel the transaction. If you're a listing agent and you become aware that a buyer's appraiser has measured the property and that there is a substantial discrepancy, that probably puts a further disclosure obligation on you, because now you know that there's a question. So you may be very, very well advised. You should disclose the fact to any later buyer. Yes, well, we had an earlier buyer measure it. The property may actually be X. The assessor says it's Y. You should measure it yourself and make sure, okay? You can't just ignore the fact that a buyer canceled the deal and said it wasn't 2,300, it was only 2,150, right? You still got to pass that information, because once you know it, you can't unknow it, right? The knowledge didn't go away. All right, so condominiums are a big problem. I mentioned lot line condos. That's interesting as well, because how does the assessor figure out how to assess a lot line condo? My guess is that they probably measure it corner to corner as if it was a freestanding home, but I can't claim to have seen enough of them and how they're assessed to tell you for sure. I just would call it out that this could cause further confusion in terms of what exactly is the square footage you're going to go with, because if the definition of the unit is otherwise like a lot, that we have actual property lines, then do we describe the square footage of the what otherwise we would call a lot, or do we just describe the residential space inside the structure? So that, I think that that's something, as lot line condos become more common, I think that's something that we're all going to have to look at and figure out how do we do that. So listing agents, listing brokers, be very vigilant. Make sure that you understand if it's an airspace condo or lot line condo. If it's older, it's usually not going to be a lot line condo, because they're a fairly new phenomenon. Most older properties, and by older I mean more than 15 years old and prior, they're typically going to be most of the time airspace condos. How are you going to know that? Well, you're going to have to go to the condo plan. The CC&Rs usually won't tell you. All right. Well, I don't want to get behind here. So let me move to the next topic. There are several appellate cases that give us significant guidance on square footage and other ways in which a real estate professional or a seller can get into trouble, despite words like approximate. In 1994, there was a case that hit the Court of Appeal called Salahutton versus Valley of California. This was involving a property in Kern County, and the area in which the acreage was located, lots could not be split unless you had at least 1 acre to begin with. So if it was 0.99 of an acre, you could not split it into smaller pieces, had to start at least with an acre. Well, Salahutton, the buyer, specifically made it clear both to the realtors and to the seller that the only reason they were buying this particular parcel, which was warranted, which was described as a 1 acre parcel, was that they wanted to split it into 2 lots and then develop it or sell it. That was the only reason they were buying the property. And everybody thought it was an acre. It was assessed as an acre. Everybody believed it was an acre. There was no actual knowledge as to the size, but unfortunately, everybody knew that the size actually was a big deal to the buyer, because they had said right up front, I'm going to split this lot, and that's why it has to be at least an acre. Well, of course, you know, you can guess the rest of the story, right? Salahutton closes escrow, goes to submit the paperwork to split the lot into 2 pieces, and is told, well, I'm sorry, but you can't, because your property is not an acre. It's a little bit less than an acre. So he sues, of course, he sues the realtor, he sues the seller, and the issue is negligent misrepresentation, because what happened there was everybody described the property as an acre when nobody really knew. It had never been measured or surveyed. And so when Salahutton relied on that material statement that this is 1 acre, that gave rise to a claim of negligent misrepresentation. And the court talked about the term constructive fraud. in my mind, in my reading of the opinion, I think they're mainly talking about negligent misrepresentation, and constructive fraud is just a different way of describing it. But that is an important case. If you know that the square footage has some particular significance to the buyer, then you need to be on heightened alert that there could be problems here if the square footage or the acreage that's quoted is inaccurate. So that puts you, in my mind, on a duty, responsibility to make sure that you tell the buyer, well, we haven't measured it. We don't know that it's an acre. You really should look into this because we're not telling you it's an acre. In the Salahutton case, unfortunately, the seller didn't make those kind of statements and left themselves open to a very painful lawsuit that is a lesson for the rest of us. So watch out when there's a special significance to the size of the property. Another case from 4 years later, from down here in Los Angeles, actually, is the case of Furla versus John Douglas. Now, this was an interesting case. This was a large freestanding home. The home was in the Mount Olympus area, just down the Arroyo Seco Parkway, a little bit from Pasadena, where I'm at right now. And it was believed to be 5,500 square feet. The assessor thought it was 5,500 square feet. There were some architectural drawings somewhere that thought it was 5,500 square feet. And the case tells us that Mr. Furla, the buyer, actually stood in the living room when he made his offer to purchase the property, and he had a calculator in his hand, and he punched in some numbers and said, I'm willing to pay this much dollars per square feet. Per square foot. So this is a guy who was calculating his price based on the alleged square footage measurement of the property. And so what happens? Well, it turns out that when he moves in, it gets measured. It's not 5,500, it's not 5,000, it's not 4,500, it's 4,300 square feet. Can you imagine? 1,200 square feet short. You know, when my wife and I first bought our first house in Pasadena, it was less than 1,200 square feet. I can just imagine Mr. Furla or his lawyer in court saying, good Lord, Your Honor, my client lost 1,200 square feet in this deal. He lost a whole house. Well, what happened then is, of course, the case goes to court. And the court said that, first of all, among a number of comments, that a 20% discrepancy is certainly not covered by Approximate. This is the only case that I've so far been able to find that specifically says what Approximate is not. Now, I'm telling you my practical experience is that Approximate is also not 10% discrepancy, that it's something smaller than that. But here we have an actual court opinion saying 20% discrepancy is certainly not covered by Approximate. So we can take this case to help reinforce the proposition that the word approximate, or the symbols plus, slash, minus, that is not an absolute protection on square footage discrepancies. So what happened in the case, and this is kind of interesting, is the case was against, as you can see, John Douglas. They originally were kicked out of the case by the trial court, but the appellate court brought John Douglas back in and sent the case back to the trial court to determine several things. And one of those things was whether the realtor from John Douglas should have noticed in their visual inspection, walking through all accessible areas of the property, if this discrepancy in size was so big, should the realtor have noticed it just walking around? Now, I would ask you, I'll bet that most of you participating in this session today would think that you could tell the difference between a 5,500 square foot and a 4,300 square foot home. I think I could too. And that's what the court was saying, is that, okay, you may not know the exact measurement, but you ought to have noticed, or I guess to be accurate, the court said, we're going to send this back to the jury and to the judge and ask them to answer the question, should the realtor from John Douglas have noticed in their reasonably diligent walkthrough inspection, should they have noticed that this, in fact, was something less than 5,500 square feet? Not that they need to figure out just by walking around what the accurate number is, but wouldn't you think that maybe you or I would have noticed that this doesn't seem like 5,500 square feet. I would like to think so. So you've got two cases now. You've got the Sal Hutton case that says, watch out. There's a special reason for the size of the property has a special reason for the buyer. There's one red flag. Here's another one where the discrepancy is so great that somebody should have said something. Somebody should have said to Mr. Furley, you know what? Before we go further, before we close escrow, this doesn't feel like 5,500 square feet. I really think this should be measured. I think you should look at your assessors, your appraisal report rather. Now, back in those days, I don't think buyers typically got to look at appraisal reports, but of course that's changed now. So there's a very scary case on square footage. And I would submit to you, it probably goes the other way too. We'll talk in a minute about when square footage is larger, but what if you saw a house that per assessor was 4,300 square feet and you walk through and you see that there's 7 bedrooms and 4 bathrooms? Wait a second. This doesn't feel like 4,300 square feet. There may have been some significant additions here that that may not have been fully permitted. So it goes both ways, larger or smaller. The third and final case I want to talk about, and by the way, before I do, we're starting to come down the home stretch. If you have questions that you'd like me to answer on this session, please use the question box to type in your questions, and I'll get to as many as I can on this subject of disclosure and square footage and property measurements and what have you. So let's go to the last case then. And this case is quite recent. I'll bet most of you have heard about this case. It just came down about a year and a half ago. This was the Horiki versus Coldwell Banker case. This was a case that got a lot of follow in the real estate law profession because it was a trial case. We all heard about the outcome. Then it went to the Court of Appeal. And then the California Supreme Court issued really a landmark decision giving all of us guidance on the subject. Well, here's the setup. Horiki is not American born. Horiki hires an agent in the Malibu Association of Realtors, but that brokerage was a Coldwell Banker office. And the seller had hired, and I may have this backwards, but the seller had another Coldwell Banker office, but in a different area. I think that was Beverly Hills. So 2 different regions, 2 different actual associations of realtors, but all under the same brokerage. And it turned out that there was information in the file of one of the 2 Coldwell Banker offices that in fact the house that Horiki was buying was significantly smaller than was represented. It was smaller than what the assessor said, and it was smaller than what was believed to be the case. The issue was not just that whether Horiki had a case for square footage, but whether he had a case against Coldwell Banker, the listing agent, who wasn't his broker, who wasn't his realtor, wasn't his realtor. The Court of Appeals said, well, you know what? You may have 2 different offices, you may have 2 different agents, but you're all agents of one brokerage, and that's Coldwell Banker. And so the knowledge of the one office was imputed to the other office, and Horiki was found to have a claim for breach of fiduciary duty because Coldwell Banker was held to be the dual agent of both the buyer and seller. And so the knowledge of the one office basically became automatically considered to be the knowledge of the other office. And that's a case that's going to take a few years to sort out because it really has some implications on multi-branch and very large brokerages in terms of how dual agency is handled. Another very similar case from about 20 years ago, 15, 20 years ago, is called Michael or Michelle versus Palo Verde Network. That was another case involving disclosure where the one realtor had certain information in the brokerage about a property but did not actually get the listing, and another agent in the same brokerage did successfully get the listing, didn't know about the first realtor's information on the property. But it all came out later after the buyer bought the property that there was this problem with the property, and somehow they discovered that there had been this inspection by this first unsuccessful realtor, and it was held against the listing brokerage, that the knowledge was all held to be under the same roof. So so sometimes, even though you may not know, the law could hold that your office knows, and could hold the brokerage responsible for that. So that's a big problem for not only for large offices, but that and the Palo Verde Network case, even modest size offices could have a situation where one agent has information which may not be actually known to another agent who actually does work on the transaction, but yet could be held against that agent who doesn't know. So maybe in another seminar we can talk about how do we deal with this transmission of knowledge about properties. Okay, what do we do when the square footage is larger? Sometimes you see a property is in the assessor and as 2,100 square feet, and you've seen 5 bedrooms and 3 bathrooms and a bonus room and on and on and on, and you know that there's a lot more square footage here. Well, of course, and particularly in the San Gabriel Valley, we have lots and lots of creative additions to property that have not been permitted. We also, and I'm starting to see this as well, we're seeing situations where property owners are making illegal accessory dwelling units. Now, oftentimes we show those as we call them granny flats. I had this question come up literally yesterday with an association in Huntington Beach. A homeowner has taken his garage and converted it into a rental. But he didn't do it with permits of the city and didn't do it with permission of the HOA. So is that going to be disclosed as part of the square footage or added to the square footage? Because we may not be considering the garage as part of the habitable space of the residence. So watch out. If you see the square footage is larger than the assessor says, then I would definitely write a letter to my client and say, hey, client, I really think you need to have somebody look down at building and safety and try to figure out what happened here, because it looks like there have been some additions that were not certified, not approved by the building and safety department. Just a quick footnote on this, by the way, speaking of accessory dwelling units and junior accessory dwelling units, a law that's sitting on the governor's desk, a bill that's sitting on the governor's desk as we speak right now on September 15, is Assembly Bill 3128. That is a bill that, if it's signed by the governor, as I expect it will, that next year, if someone applies to the building and safety department for an accessory dwelling unit or a junior accessory dwelling unit, that the building and safety department has 60 days to respond to that application, or it's deemed automatically approved. Can you imagine? Automatically approved. So that's going to create some really interesting situations. I think ADUs and junior ADUs are something that we're going to be dealing with more and more, and I think they're going to create a whole new set of problems that we don't have time to go into today. But watch out for illegal additions and illegal granny flats or junior granny flat conversions. Okay. How to protect the buyer. A couple of quick risk management tips as we come down the home stretch here. First of all, how do we protect the buyer? Well, the best way is to educate them and to compare make sure that they compare the appraisal report to the assessor information. Now, we all know that if there's a lender involved and there's an appraisal involved, that the buyers have a right now to see the appraisal report before they close escrow. Well, don't wait until the day before everything funds to look at that report. Look at it much sooner, because that is almost always going to be, with respect to condominiums, that's going to be when you're going to find out about square footage discrepancies. You're going to find out about that when you see that the appraiser says it's only 2,150 square feet. It's not 2,300. So make sure they look at the appraisal report, and don't wait until the last day, because if they know the property is different than what they thought, and they have time to cancel, they could arguably be held to have accepted that discrepancy. So I would definitely have a lawyer look at it and make an informed decision about whether you want to cancel or close, because it would be a shame if somebody closed escrow thinking that they still had a lawsuit, and then later they were found to have accepted the discrepancy because they knew about it and they went ahead and closed anyway. Now, so that's obviously another way to protect the buyer is, of course, educating them to understand that square footage is assessor square footage is often not terribly accurate. Okay. All right. So how do we protect you? Well, one great way is to use all the available California Association of Realtors forms. And there are a bunch that talk about square footage. I don't think I found them all, but here are at least 5. The buyer representation agreements, the exclusive and non-exclusive at 6B8, have a statement that informs the buyer that the licensee, that the realtor is not independently measuring or warranting the size of the property. Similar statement is found in the buyer's inspection advisory at section 3B. There is a buyer material issues disclosure that's a little bit newer at 4B8. It talks about square footage. And of course, the statewide buyer and seller advisory, the SBSA form at section A10, it informs the buyer that, hey, square footage may not be accurate, may not be have been measured. You want to check it yourself. And there's a brand new form, the square footage and lot size disclosure and advisory form. This form just came hot off the presses in June of 2020. And this is a download. I hope that before you end your participation today, that you will take a look at that download. I've put it on the screen here. Let me see if I can enlarge it. Okay, so this is what the form looks like. It is a one-page form, and it basically says a lot of the things that I've been telling you today, but it specifically asks the seller to look more closely at the size information, the dimension information, and make a little bit more accurate disclosure. I think that if you're a listing broker, listing agent, this is a really good form that can help protect your sellers. I don't know if as a buyer you can demand that there be a square footage and lot size disclosure and advisory as one of the conditions of your offer. I hope and assume you're also in your offers insisting as a condition on the seller's property questionnaire. So perhaps you could ask as a buyer for this to be part of the conditions as well, that the seller use the SFLS form. But I would take a look at this, download it. I've got the sample form here in the materials. If you click on the handouts tab, you'll see that's the only handout that I've got today. So, all right, well, I'm just about out of time. Let me move on. A lot of brokers have a variety of custom disclosures. Here's just a sample of a possible disclosure. I really don't think that you want to do this on your own. I think you want to talk to your broker and have your broker check with their counsel, whoever he or she is, and develop some type of disclosure language that works for your brokerage. One of the things that I have done here is just to give you an idea that says that the buyer will, in its inspections of the property, that they will independently measure the property, and that buyer understands that seller has not measured the property. Now, I understand that's a little bit redundant with some of the disclosures in the Sierra forms already. If buyer elects not to measure the property, buyer agrees that the stated size of the property is as stated, regardless of any other later discrepancy. Something like that. Now, You may want to go further. You may want to, your broker may think that this goes a little bit too far. But the idea here is that uh, because square footages can be such a devastating issue, because it creates lawsuits, because unfortunately jurors and sometimes judges think that these discrepancies are not entirely accidental, it's maybe a good idea to take a little extra time and have a disclosure of your own brokerage's creation on square footage or lot size. And particularly with condos, you might have one for condos and you might have a different one for land or for freestanding structures. But I think that that would be a very helpful way to protect yourself as well as your client seller. How also to protect yourself? Again, I can't say it enough. Educate your clients. Um, Help them understand that square footage quotes are very often inaccurate, that the assessor information is interesting, but it's not legally reliable, that they really must check their appraisal report, look at that square footage before they close escrow. And with condos, you know what? Just expect that the size of the condo, as stated by the original developer and the assessor, are going to be overstated. So, coming down the final turn here, one of my favorite shows from the 80s was Hill Street Blues. And many of you that watched that show may remember how each briefing would end with Sergeant Esterhaus. This actor, unfortunately, is no longer with us, but that was his tagline: let's be careful out there. So I want to exhort you, realtors, I appreciate you taking the time to attend this session today. And if you've attended one of my presentations before, you've probably seen this slide. But I just want to encourage you, be successful, and success also includes caution. It includes thoughtfulness and protecting yourself and protecting your clients from surprises. So be careful out there. I want to thank you for listening today. I'm out of time, but let me see if I can squeeze a couple of questions in. I appreciate those of you who have submitted questions. Let me see if I can do this here. If we use the question box, trying to open the questions. There we go. Okay. One question is, how would an agent avoid the risk of measurements? How can agents avoid risk of measurements in a measurement differences in a condo transaction? Well, I think this question may have been submitted a few minutes ago, but I think first and foremost, number one, expect that there's going to be a discrepancy. Number two, beg your client not to anchor on the original developer brochure or the assessor information. And three, look at the appraisal report. If it's an all cash deal and they don't have an appraiser, you can hire an appraiser. They are trained to properly measure the residence. And I think that would be a great way at a fairly low cost to get that protection that your client needs. Okay. I want to apologize for anybody else who I have some other questions that I'm not going to be able to get to because I'm at my 1 hour promised deadline. I want to thank all of you for attending very much. I hope you've enjoyed this presentation. I believe it will be posted as a recording on the Arcadia Association of Realtors website, so other people can take advantage of it there. Please take the download, look at that new form from CR that came out in June. And you'll get a short poll after the presentation. It'll ask you for some input so I can know how to do things better. I want to thank all of you very, very much for attending. I wish you all a great rest of your day and much success. Thanks all, and I'll sign off now. Bye-bye.